Americans have equal rights. Each state's Bill or Declaration of Rights applies equally to all Americans. Rights are common. Each American state has a Bill of Rights or Declaration of Rights. These rights were written down by the people before some of the state constitutions were created. These are known as common law as they are applicable to all mankind, common to all people. The rights are not specific to the people within each state. The people within the state wrote down what they considered to be natural rights for all mankind. Not all inclusive. Each state will have similar subjects within their Bill of Rights. However, the wording may be different from state to state. It was well known among the Founding Fathers that these written lists of rights did not include all of the people's natural rights. The lists were not all inclusive, but merely listed some of the people's rights. Natural right. Natural means pertaining to nature, produced or affected by nature, or by the laws of growth, formation, or motion impressed on bodies or beings by divine power. Natural rights are those which grow out of the nature of man and depend upon personality, as distinguished from such as are created by law and depend upon civilized society, or they are those which are plainly assured by natural law. People are born with natural rights, thereby being inherent, which means existing within you. So the difference is a natural right is one that's given to you, you're born with it, and it comes from God, as opposed to those that are created by law from mankind. Maxims of law. Every right is either made by consent, or is constituted by necessity, or is established by custom, or created in us by the decrees of providence. Natural right is that which has the same force among all men. Natural rights are such as appertain to man, inherent in his nature, or plainly assured by natural law, being distinguished from such as are created by law and depend upon civilized society. These are Maxims of Law by Charles Weisman. Bible Scriptures. The principles for equal rights came from the Bible. So here are some examples of scriptures. The first one being Matthew chapter 23, verse 8. It states, "But be not ye called Rabbi, for one is your master, even Christ, and all ye are brethren." Galatians chapter 3, verse 28. "There is neither Jew nor Greek. There is neither bond nor free. There is neither male nor female, for ye are all one in Christ Jesus." Acts chapter 10, verse 34. "Then Peter opened his mouth and said, Of a truth I perceive that God is no respecter of persons." You see, all of these are referring to the people being on the same level together, referring to them as brethren or all one. And no respecter of persons means that he considers them all equal, all the same. And this is the concepts of where our equal rights came from for our Bill of Rights. Samuel Adams said, "In the supposed state of nature, all men are equally bound by the laws of nature, or to speak more properly, the laws of the Creator. They are imprinted by the finger of God on the heart of man. Thou shalt do no injury to thy neighbor is the voice of nature and reason, and it is confirmed by written revelation." Here's an example of a Bill of Rights from the Alaska Constitution, Article 1, Section 1, regarding inherent rights. It states, "This Constitution is dedicated to the principles that all persons have a natural right to life, liberty, the pursuit of happiness, and the enjoyment of the rewards of their own industry, that all persons are equal and entitled to equal rights, opportunities, and protection under the law, and that all persons have corresponding obligations to the people and to the state." The word principle means a fundamental truth or doctrine as of law, a settled rule of action, procedure, or legal determination. So it was a common principle and known at that time period that all persons had natural rights and were equal in all of their rights. So it wasn't particular to just that one particular state. It is applied to everyone. Here is the Arkansas Constitution, Article 2, Section 3, entitled Equality Before the Law. "The equality of all persons before the law is recognized and shall ever remain inviolate, nor shall any citizen ever be deprived of any right, privilege, or immunity, nor exempted from any burden or duty on account of race, color, or previous condition. You see here another example. It doesn't say the people within Arkansas. It says all persons. And it also says any right, privilege, or immunity. So it's referring to a right that pertains to everyone. In the Connecticut Constitution, Article 1, Section 1, it states, all men, when they form a social compact, are equal in rights, and no man or set of men are entitled to exclusive public emoluments or privileges from the community. The word compact means a contract between parties which creates obligations and rights capable of being enforced, and contemplated as such between the parties in their distinct and independent characters. Notice that in the Connecticut Constitution, they did not say just for the people within Connecticut. It states all men have equal rights. Missouri Constitution, Article 1, Section 2 states, under titled Promotion of General Welfare, Natural Rights of Persons, Equality under the Law, Purpose of Government, that all constitutional government is intended to promote the general welfare of the people, that all persons have a natural right to life, liberty, the pursuit of happiness, and the enjoyment of the gains of their own industry, that all persons are created equal and are entitled to equal rights and opportunity under the law, that to give security to these things is the principal office of government, and that when government does not confer this security, it fails in its chief design. So again, here's another example. It states all constitutional government. It's referring to all persons have natural rights, and all persons are created equal with equal rights. United States Constitution. In the United States Constitution, Article 4, Section 2, Paragraph 1, it states, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. The federal Constitution was ratified, which means accepted and confirmed by the states in 1787. The Bill of Rights and some state constitutions existed before the federal Constitution. You use your state constitutions to secure your rights, not the federal Constitution. Immunity means freedom or exemption from obligation. Reserved powers. In the U.S. Constitution, Amendment 10, it states, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved, which means to hold back, to the states respectively, or to the people. So it's stating here that the powers that were not delegated to the United States are reserved to the people. The U.S. Constitution Amendment 9 states, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So what it means by enumeration is simply the listing of the rights within the Constitution. So it's saying it does not deny or disparage those that are retained by the people because the people retain their rights. And disparage means to connect unequally or to match unsuitably. So in other words, everyone has the same rights. Here's a diagram for you. At the top of the diagram, the people wrote down their natural rights, and they called them the Bill of Rights, or in some states they call them Declaration of Rights. Your Bill of Rights or Declaration of Rights is where your highest power and authority resides. The people got together and created state constitutions, and within the state constitutions, they include your Bill of Rights or the Declaration of Rights. The states got together and created the federal Constitution. Some rights are listed. However, the federal Constitution refers back to the states or to the people, and that's what I just read to you before. They are reserved to the states or to the people. Here's another illustration for you. The individual states gathered together and formed a social compact for their mutual defense and benefit, calling it a federal government, the United States of America. So if you look at the blue circle there, I have 9 states listed. The reason I only have 9 states listed is because it was 9 states that brought the initial federal government into being. I didn't have room to put all 50, but all 50 states are included within the United States of America. So when those 9 states got together and decided to form a social compact. Their rights, their individual bills and declarations of rights, then became applicable to everyone within that social compact. As stated in the Connecticut Constitution, all men, when they form a social compact, are equal in rights. So now today we have 50 states, and all 50 state bill or declaration of rights are applicable to everyone in all states in America. Benjamin Franklin said, "The ordaining of laws in favor of one part of the nation to the prejudice and oppression of another is certainly the most erroneous and mistaken policy. An equal dispensation of protection, rights, privileges, and advantages is what every part is entitled to and ought to enjoy." In summary, the states gathered together and formed a social compact. This compact is known as the federal government and is titled the United States of America. When a social compact is formed, all the people within that compact have equal rights as stated by law. Therefore, the bills and declaration of rights stated within each state's constitutions are equally applicable to all Americans. I hope this has been helpful for you. Thank you for watching, and please share this with others.